and welcome back to Chapter 4 in your commercial law curriculum. This chapter is Consideration, the Value for the Promise. Just to reorient you as to what we've been talking about, remember there are two different tools that we use to evaluate or analyze contracts. One is the common law and one is the Uniform Commercial Code. And which tool you use depends largely on the parties involved and or the subject matter of the contract. At this point, we're still working on the common law elements of a contract as opposed to the UCC. And to keep in mind, every time we analyze a contract, we're going to go through those components, and each and every component must be there in order for us to have a valid and legally binding agreement between the parties. Those components are offer, acceptance, consideration, mutual assent, capacity, legality, and sometimes legal form, having that contract in writing. We've been through offer and acceptance, and today we're going to start talking about consideration, the value for the promise. In any discussion of contracts, any analysis of contract, invariably the concept of consideration comes up, and most people think that they understand what consideration is. Most people probably think money when they think consideration. I want to tell you this up front. In order to properly understand and comprehend the concept of consideration, you must first rid yourself of the misconception that consideration is only money. So you're going to have to rid yourself of that notion of evaluating consideration from a subjective standpoint. In other words, what's valuable to you. You have to back off and look at consideration objectively. Valuable to you may not be valuable to someone else, and vice versa. The most important thing to keep in mind while learning about consideration is that it's a necessary element in a valid contract. Courts will often do whatever is necessary to find it, and with few exceptions, consideration must exist for there to be a binding contract. Remember that consideration can be something of great value or little value. The amount doesn't matter. Very important concept. The amount doesn't matter as long as it is present. So before we get to our working definition of consideration, keep in mind that it doesn't have to be money. Value is whatever the parties think it is. The amount of the consideration doesn't matter. And the consideration is important because it proves that the parties intend to be bound to an enforceable agreement. Remember, we're working towards finding a legally enforceable agreement between the parties, and consideration is an absolutely necessary portion of that. So, myths aside, what is the definition of consideration? Well, it's a detriment or a benefit bargained for between the parties, something of worth to the parties, and a promise between the parties. And of course, the value must be legal. If something is illegal, doesn't count as consideration. Let's go through each part of the definition. First, the detriment or a benefit. What do we mean by that? Well, the first part of this definition states that there must be a benefit or a detriment to the parties. It means each party to the contract, each side, gains something or gives something up in the process of creating a contract. When gain to a party is found, it's called a benefit. When a sacrifice occurs, it's called a detriment. So let's look at an example. There's a good one in your book. Assume that your friend offers you $100 for not eating chocolate for a whole month. You have a legal right to eat chocolate. But if you want to earn the $100, you have to give chocolate up. That is, forbear from eating it. That forbearance is a valid detriment and a benefit from your eating healthy, and your detriment is not eating the chocolate you love. So a benefit on one side, a detriment on the other. The next element of the definition is a bargain for exchange between the parties. Now let's think back to our definitions of bilateral and unilateral contract. In a bilateral contract, a promise is exchanged for a promise. In a unilateral contract, a promise is exchanged for an act or a forbearance of an act. The focus is on the exchange of promises between the parties and the benefits and detriments to both. This is the concept known as mutuality. Mutuality exists between the parties when both sides have a benefit and a detriment. Let's look at that by analyzing our chocolate example. So again, the contract is, or the offer is, I will pay my friend $100 if they forbear from eating chocolate. Okay, so the benefit on the detriment on my side is the offeror is benefit, my friend lives a more healthy lifestyle. Detriment, I give up $100. So on the offeror side, we have both the benefit and the detriment. Looking on the offeree side, we have both a benefit and a detriment as well, right? The benefit is the offeror is going to get $100. The detriment is the offeror can't eat chocolate, gives up a legal right to eat chocolate. So in this case, we have the doctrine of mutuality satisfied, and we have the bargain for exchange that creates mutuality. Okay, so the next concept is that everything has to be for value, right? The bargain for exchange for value. Critical to the concept of consideration is that the exchange must be for something of value to the parties. Note, the parties decide on the value. It's not what you and I would deem valuable, it's what the parties involved in the contractual process deem valuable. So again, it's that objective valuation, not subjective, where you and I do it. Objective, what they do. And again, the value doesn't have to be money. It certainly can be money. It certainly often is money, but it can also be services. It can be property, or as we see in our chocolate example, acts of forbearance. All of those things constitute value. So if we look at brief examples of each one of these, for example, if a contractor offers $5,000 to an electrician for installing all of the electrical wiring in a house, the exchange of promises is that the electrician will provide wiring in exchange for $5,000, so the value is money there, right? Property exchanges occur between parties, and they also constitute valid value. For example, if I own a computer and need the use of a printer, I can ask my friend who has a printer but no computer to allow me to use the printer 3 times a week in exchange for the use of my computer every morning from 9 to 11:30 a.m. Consideration is the exchange of property, and it's valuable to both sides. There's a benefit and a detriment on both sides, so we have value there. Okay, how about acts of forbearance? If you request somebody to refrain from doing something that they have a legal right to do, that's considered value, just like in our chocolate example. Or if I ask you to stop smoking, that's giving up a legal right. So you can create valid and enforceable agreements through money, services, property, acts of forbearance, and other things that people consider valuable. Okay, remember that there must be a promise between the parties. The difference between a promise between the parties and just turning something over is the difference between creating a contract and a gift. Think about this example. If I promise to give you my phone and you take it, what's the promise between the parties? There is none, right? I promised to give it to you, I did, you took it. You didn't promise me anything in exchange. So what did we create there? We created a situation where there was a gift. I gave you my phone for free, as opposed to a situation where I promised to give you my phone and you promised to give me $50 in exchange. There's the promise between the parties, but we didn't have that. Okay, and finally, remember that the value must be legal. You can't do something illegal and have it be the value or the consideration that's the basis for a contract. In other words, if I offered to sell you stolen property, well, I don't have title to that property, so it's illegal for me to have it, it's illegal for me to sell it. So that can't be considered valid consideration. Take a look at Exhibit 4.1 or 4-1 in your book. It's got the elements of consideration there. It's a good one to put a tab on so you can come back to it throughout the semester as we're analyzing contracts. Now that we know the elements of consideration, let's take a look at the discussion regarding the adequacy of consideration. What I want you to understand is the courts don't have a predetermined set of rules to decide how much consideration is enough to bind a contract, because it's such an objective standard. It's the parties to the contract. Courts normally don't like to question the amount of the value, and in fact, you'll often see at the beginning of a contract, for $1 and other good and valuable consideration, the receipt and sufficiency of which the parties hereby acknowledge. And that's just that's showing the courts that the parties to the contract have agreed that there is good and valuable consideration for the agreement. Even if it's a large services contract worth millions of dollars, if they've got that language in there, it's probably going to suffice for the courts. So it's an interesting concept, but Nominal consideration demonstrates that there was an exchange there. Some exceptions, if there's a sham, fraud, duress, misrepresentation, in other words, one party has misrepresented a fact. If there's undue influence, someone is in a position of responsibility and unduly influences the other party. If one party was mistaken as to the consideration, or if we have a situation where there's unconscionability, right? It's the contract is too heavily weighted in one side's favor. But again, the courts don't normally like to question it unless one of these exceptions is present. What about the absence of consideration? Take a look at Exhibit 4-2 in your book. There's a good list of some of the situations when there is an absence of consideration. But remember, if we don't have each one of the elements or components of a contract, we don't have a legally enforceable agreement. So when consideration is absent, the court will not enforce a contract made between the parties. Because consideration is a necessary element in contract formation, the lack of it renders the contract invalid, unless, of course, an exception exists. Normally, in gifts, we have no consideration. So the promise of a gift, therefore, is a normally unenforceable situation. Also take a look at illusory promises and moral consideration. Those are two areas that you want to be careful of when you're analyzing consideration. Illusory promises are promises based on a party's wishes, desires, or hopes, and usually, again, are not adequate basis for a contract. Words or phrases that suggest an illusory promise are, hey, we'll order your products when you need them, or we will order the product as demand dictates, or we will request shipment of your product when we wish. None of these creates the mutuality of obligation we need between the parties, and therefore doesn't create consideration or binding consideration. A promise to compensate for a past moral obligation is also unsupported by consideration and is therefore unenforceable. For instance, if you're out walking down the street, you trip over the sidewalk and you break your ankle, and a passerby helps you up, puts you into a car, and takes you to the hospital. Once you get to the hospital, you say, you know what, that was really nice. I promised to give you a gold Rolex watch for that. That is a promise for past moral obligation, and therefore it's not considered consideration. If you had said when you tripped, hey, if you pick me up and take me to the hospital, I will give you a gold Rolex watch. Now we've got a different situation because it's a bargain for exchange beforehand, but that the fact that you didn't say until after it had already been done and there was no expectation when the passerby helped you up and put you in the car and took you to the hospital, no expectation of payment at that time renders it past moral obligation and therefore not enforceable. It's a very similar situation to past consideration, something already given. Courts may find an equitable basis to enforce that, but if the value has already been given before the promise is made, it's past consideration. Closely related to past consideration is the pre-existing duty rule. When a person has a pre-existing responsibility to act or refrain from doing something, there's no bargain for exchange. The obligation exists either by law or prior agreement, and therefore the law doesn't infer additional consideration or detriment suffered. Under this rule, consideration can't be bargained for between the parties, as the responsibility to act or refrain from acting is already a duty. There's a very famous example of a Hollywood movie star who signed an agreement to participate in a movie. Once the movie was set up and going, they threatened to walk off unless and until the movie house agreed to pay them more money. Well, of course, there's millions of dollars going out the door every day to set up that movie stage, and the movie house felt like they were over a barrel, so they promised that they would pay more. Even though the actor already had the obligation, the pre-existing duty to be there and to participate in the movie. So at the end of the movie, when it was all done and in the can, so to speak, to use the industry jargon, the movie house refused to pay that additional consideration, and the courts came down on the movie house's side, saying that the actor had a pre-existing duty to participate in the movie and be there on set, and so there was no mutuality there. Promissory estoppel is another concept we need to be aware of when we're looking at consideration. And promissory estoppel focuses on principles of justice and fairness. In this case, although no traditional consideration is apparent from the promises, if a party changes his or her position in reliance on a promise, the courts may imply some consideration exists. An example would be if a wealthy person during their lifetime promises to, in their will, give a gift of a certain artifact to a museum, and the museum, in reliance on that promise, builds a new wing onto their building. And then when the wealthy person actually passes away and the will is probated, that promise didn't make it into the written will. Well, the courts may say that that promise is enforceable because the museum relied on that promise to their detriment and spent a lot of money preparing for accepting the artifact. So just to review and wrap everything up, remember that the elements of consideration are that there must be a detriment and or a benefit to each side. It's a bargain for exchange. Remember the doctrine of mutuality. It has to be for value, although that value is an objective standard. The promise between the parties is important. It's a promise as opposed to a gift, and the value must be legal. That's all for Chapter 4. As always, if you have questions, comments, or concerns, don't hesitate to contact me, and we'll see you back here for Chapter 5. Have a great day.